Well, this is how the daily go. Don't switch that dial right now. You're tuning into Edge 105. Dre Island representing.
Dre Island, thank you very, very much. All right, well, here we go. It's often when we read about the financial meltdown of various institutions in Jamaica that there is invariably in the midst of a report we hear about the appointment of a receiver. This came up most recently in connection with the saga involving Stocks and Securities Limited, SSL, whose employee is alleged to have defrauded millions from SSL investors. But who really is a receiver? And what does it mean when it is said that a company is in receivership? Is a receiver only appointed over a company? Or can a receiver be appointed over our personal assets and business affairs? What can a receiver do or not do? These are some of the questions which we'll ask our guest this afternoon. And our guest this afternoon is Julianne Mais Cox, a partner at DunnCox Attorneys-at-Law. Julianne, thank you so much for joining us.
Good evening, Dion. A pleasure joining you once again on the legal landscape. And good evening, of course, to all the listeners.
Well, we have our listeners on the edge of their seats for another episode. You always come with some marvelous topics. Let's start off, Julianne, first of all, who is a receiver?
Dion, I think at the outset it's necessary to set the stage because I want to point out that the concept of a receiver is not a straightforward area in law, and large texts have been written on the subject of receiverships and the duties and obligations of receivers. And this is so not least because there are several pieces of legislation and therefore various circumstances in which a receiver may be appointed and be relevant. And just generally those will include, with respect to real estate under the Registration of Titles Act, with respect to personal property under the Security Interest in Personal Property Act or SIPA, the Insolvency Act, Companies Act, POCA, the Proceeds of Crime Act, under the Judicature Supreme Court Act. So generally a receiver, or sometimes receiver manager, is someone, or it can be joint receivers, who is appointed by a lender that holds a mortgage or charge over the property or assets of a borrower, or someone appointed as receiver by the court. And in either case, whether appointed under an instrument or appointed by the court, as a power to secure, take possession, custody, and control of the assets or particular property, manage them, receive the income from them, and will usually have the power to sell the property and the assets in question, and then apply the proceeds of sale in satisfaction of the debt owed to the lender. Now, that is a mouthful, Jan, but in a nutshell, in many instances, a receiver is a person who can take over the day-to-day running of your company or your business after it's fallen into financial difficulties and take control of selling the assets to pay the debt.
Wow, it really does feel like a mouthful, Julianne. But let me ask you, how do the banks, mortgage companies and lenders generally appoint receivers?
I refer to those types of appointments as privately appointed receivers as opposed to the receivers appointed by the court. So the process generally to appoint a receiver can actually be very quick and cost-effective for the lender. The first step is to carefully review the security document to ensure it's enforceable and the correct procedure is followed. And then the lender security documentation will usually set out when a receiver can be appointed, which is usually, of course, where there's non-payment by the borrower. Now, the appointment is not court-led. So an appointment on a mortgage regarding registered land, for instance, simply involves a lender writing to the receiver, requesting that they're appointed over a particular property or properties, and the receiver agreeing to the appointment. And then the receiver will inform the debtor of the appointment, and under the Registration of Titles Act, for instance, within 30 days of the appointment of the receiver is actually registered on your certificate of title. And just to add that where the receiver or receiver manager is appointed over the property and assets of a company, then the company name on its documents, like its letterhead and its invoices, are going to state that a receiver manager has been appointed. And that is where you'll see a company no longer XYZ Limited, but it's being referred to as XYZ Limited in receivership.
So what does the privately appointed receiver do, and what are the benefits then to the lender?
Good question, because we should all know this. Now, one has to look carefully at those mortgage, deeds when you're buying a house. Look at the security and finance agreements when you're borrowing to fund your company or you're purchasing machinery and equipment for, your startup business. Look at it. You may see included a clause that gives the lender the option of appointing a receiver should you be in default of your loan repayments or in other circumstances, which are going to be set out in the agreement. Now, the powers of the receiver or receiver manager can include that the receiver will insure the property in question, by court action or otherwise collect the income of the property or the business that may be due to the debtor. So, such as collect rent from the debtor's own tenant if the property is leased, and then use that money to pay down on the debt the debtor owes to the lender who appointed that receiver. And the receiver may be entitled to enter into new leases, terminate contracts, make improvements to the property in question, such as if a receiver is taking over an ongoing property development, he can hire contractors and architects and complete the same. The receiver will have the power to sell the property in question for the benefit of the lender. And you had asked about the benefits of the lender. Quickly, I'll mention four. First, well, it's quick, easy, and cost-effective, as mentioned. It's as quick and easy as writing a letter of appointment. Furthermore, the receiver's fees and costs of the receivership are recoverable from the borrower. Secondly, the receiver is a borrower's agent. Now, this is quite a unique circumstance of receivership. While the borrower has no say in the appointment of the receiver, including who should be appointed, cannot give instructions to the receiver, cannot dismiss the receiver. Once appointed, it is usual that the receiver is a borrower's agent and steps into the borrower's shoes. So this is something to look for in your mortgage deeds and security documents when you're borrowing, and understand, what does that really mean? With a mortgage, for instance, the receiver being the mortgagor, that's the borrower's agent, offers protection to the mortgage company so that it is not responsible for the acts or omissions of the receiver in carrying out his or her duties, and it takes away the mortgage company's risk of dealing with the property in question. Thirdly, Dion, the receiver's main goal, of course, is to repay his or her lender. So one must remember that when a receiver is managing a mortgage borrower's property, for instance, he or she is not doing so for the benefit of the borrower, but for the benefit of the mortgage lender, and the receiver's decision will be made accordingly with that in mind, within certain parameters. Lastly, separation in contentious situations, meaning that having a receiver in place can provide some degree of separation between a lender and the borrower, which can be helpful, for instance, if the relationship between them has broken down.
Okay, I'm going to ask if you can answer me this one quickly. Does the privately appointed receiver have any obligations to the borrower?
Certainly, Dion. The receiver's main goal, of course, is to repay. This is a privately appointed receiver,
yes,
to repay his or her lender. But in discharging duties as receiver, there are some obligations which will touch and concern the borrower. For example, a receiver who is taking steps to sell personal property that was maybe security for a loan, like fixtures, fittings, equipment, your machinery, has a duty to act honestly and in good faith, and under that simple legislation to dispose of the property in a commercially reasonable manner, taking all appropriate steps to obtain the best price reasonably obtainable in the market at the time of sale. And until then, has a duty to manage the business for the better disposal of the assets, not for the benefit of the borrower, but for the better disposal of the assets. The receiver will also have a duty to provide proper account of his receipts and payments during the course of the receivership.
Julian, I must ask you this one before we go. When a business is in trouble, hear the words liquidation and receivership as if they are interchangeable. Are they basically the same thing?
Well, generally, they do mean that a company or business is in some serious financial difficulties and that the management has had to give up control of the company, but they're not the same. In a liquidation or winding up of a company, that's a process where the trustee in bankruptcy collects and sells off the assets to pay the debts and then dissolves the company, meaning that it's removed from the register of companies. In receivership, on the other hand, does not necessarily mean the end of the company. It's possible, depending on the circumstances, that once the receivers have fulfilled their appointed role of paying off a particular debt, the company can be handed back to its directors and shareholders and resume its business. And another quick difference is a receiver is concerned with the best return for the lender who appointed him or her, whereas a trustee in bankruptcy has a duty to all the creditors and not just to a particular one.
We know there are lots of persons going through various situations right now. So if there's anyone with any questions about this topic or any other legal queries, where do they go to?
Well, they come straight to me at DunnCox, or to DunnCox generally, of course.
Do you want to give the telephone number or website?
Yes, we're 876-922-1500-9. We're located at 48 Duke Street. We also have an office in Montego Bay. And we do have our website. DunnCox.com will get you there.
Great. Great.
Yeah.
All right. Well, you've heard how to contact if you have any questions for receivers, receivership, or anything along that line. You may feel free to go to DunnCox.com. And before you leave, any hashtag did you know tidbits for us? We always look forward to that.
Oh, I know you do. I don't know if this is so interesting, but I thought it was pretty interesting recently with this whole Mystic Mountain saga, because that is the subject of receivership and bankruptcy, that the same person can actually act as both a receiver and a trustee in bankruptcy at the exact same time. One person wearing two very different hats, having quite different roles, and that is something that the court has confirmed just last year.
Well, it can be done. Well, listen, thank you so very much. I know it's been a long one, but a necessary one with everything that quite a few people are going through. So we look forward to having you next week again.
Definitely, and there's so much more. I didn't even get to touch on the court-appointed receivers. So,
I know.
Take care,
I
Dion.
know. Thank you so very much. Julianne Mais Cox is a partner at DunnCox Attorneys-at-Law. And again, please feel free to contact them. 876-922-1500 if you have more personal questions you want to ask, or go to www.dunncox.com. That's a Legal Landscape for this week, Season 6, Episode 9. The topic's receivers. Who are they and how are they useful?